How many people work with Gassman today? Wow. Started with a handful, then you became a client, and you've got like 40% of the room. It's quite impressive. So I would like to introduce Alan, and he's going to be doing the estate planning asset protection. If you would please help me bring Alan to the stage. Thank you.
How's your day going? All right, got Todd and Jeff here. Thank you everybody for raising your hand and then touching your wallet. So I was actually a little nervous this morning because David was only going to give me 45 minutes, which is, most of you know, is 1 billable hour in our language. And then he said I get an hour and 15 minutes, which is actually 1.5 billable hours in our language. So I'm going to make sure that I have time for questions and answers. So think about what you want your questions and answers to be. And you can finally talk to me for free. I know it's a very, very rare event. So, you know, we've been talking a lot about money today. We've been talking about making money. We've been talking about enjoying our businesses. And now I think we want to talk about something that's also important, and that is protecting your family and your loved ones. And I don't know about you, but I think that there's a moral obligation that most of us feel to protect our families and our loved ones. And as a trust and estate lawyer who sometimes administers estates of people who didn't think it out right, I can just tell you that it's excruciating to lose a family member and then on top of that, just have a big mess. So I hate to come across like that, but I feel like I should come across like that because it's the brutal truth. You know, Woody Allen said, yeah, I have a low threshold of death and all that's funny and none of us are ever gonna die, but this stuff does hit the fan. So I just wanna make sure that you are equipped for it. And we're videoing this session. If you want a copy of the tape later, that is absolutely fine. So I'm gonna go, you've got some of these here, and I'm gonna go slower than usual so that some of you will know what I said at the end. And my thought is, why would you wait until you got to Maui to get your estate planning done? When you get to Maui, you should be thinking about your business and your success and not having to deal with your estate planning, to be quite candid. So I've gone to Maui many times and I've talked all about estate planning, but just get it done. It's not rocket science for most of you. And the Paredes principle applies. The Paredes principle, as you know, says 20% of the effort gives you 80% of the result. Get step one done. If you're hit by a bus, who should be in charge and who's going to be the guardian of your children and who can we trust to run your business? At least get something in short form done, please. So number one, do you know what you have? Some of you do, some of you don't. And what we do, and I recommend that what you do if you can, is handwrite a chart. And in that chart, have a circle for you and a circle for your significant other, or a square if they're square, I guess. And then below that, what do you own? What are these things that you own? And then below that, what are these things that these things own? And then how are they connected so that you can see it visually? Because I can tell you it's really hard to plan an estate looking at a financial statement. It doesn't really tell me what is where, and the client and the other advisors cannot conceptualize what is where. So take the time, draw it out on a chart, and I'm going to be showing you one of our simpler charts in a few minutes. So number two, near and dear to everyone's heart should be creditor protection. We'll be talking about that. And a lot of times that's what gets you in my door because you're afraid of getting sued. And then thank heaven while you're there, I can also make sure your family's protected if there's a death and maybe actually even save you a bunch of taxes if we can. So number three is estate tax protection. Now for a lot of us, estate tax protection may not be a concern. Everybody here has a $12,920,000 estate tax exemption. That's federal. You may have issues in the state where you live, but California has no estate tax, so that's good. New York, New Jersey, not so good. They do have estate taxes at lower thresholds. So if I die and I'm below 12,090,000, then I don't have to worry about the federal estate tax. But that goes up with inflation every year. It goes up with what's called chained inflation. When the government tells you things go up by inflation, they don't go up by inflation. They go up by about 2/3 of the rate of inflation. That's called chained inflation. So that exemption, 12,920,000, next year will be chained inflation raised, and then in 2026, it goes down to half. So it's going to be about 7 million per person in 2026, unless we have a president, a Senate, and a House of Representatives that agrees to the contrary. Now, in my prediction is that we will have a president, a Senate, and a House of Representatives who get a ton of campaign contributions and will keep it up. I don't think it's coming down, but it may come down. So I have a $12,920,000 exemption, and my wife, Marcia, has a $12,920,000 exemption. So if we do this right, we could pass $26 million worth of assets estate tax-free. But if that comes down, then we'll only have a $12,920,000 estate tax exemption. So it's a big thing. I'm not going to talk a lot about the estate tax here, other than to say that it is a fascinating, interesting thing for a geek like me, and that we have a lot of amazing techniques where we can just cause a couple $100 million to kind of go into this trust that's not subject to estate tax, and it's a lot of fun. So, number 4, near and dear to many hearts, is protection from the subsequent spouse. I bring it up here because people don't always think about it, but I could just tell you, and I've said this before, but usually, and I'm going to be sexist here because statistically, you know, the wife dies and the husband goes to the funeral, and at that funeral is the next wife. Because he wants somebody he knows. And they start grabbing him right there at that funeral, maybe a little after. They're taking him cookies and then cake and then gin and then, you know, whatever it is. And then her children are much cuter than his children. And then she doesn't get along with the older children, and I think you know where this is going. So one thing I do suggest you consider, and it's rare, but we do them, is just a simple agreement that says if one of us dies, 65% or whatever you choose of the assets will go into an asset protection trust, which will be only for the surviving spouse and our common descendants. And by the way, the asset protection trust will be in a nice state like Nevada where creditors have a hard time reaching in. Because for a lot of you, it's easy to do the asset protection work because I could just put everything in Marcia's name. You guys could sue me. I could file a Chapter 7 bankruptcy. Marcia keeps her stuff. You get nothing. But then Marcia dies, leaves everything to me. I get sued. Uh-oh. So that's why protection from the next spouse is a good idea. Number 5, and I'll say this a few times, never, ever, 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 ever leave assets directly to a person. Leave it in a trust for a person. This goes back to the common law of England, 1776. By the way, when Florida became a state in 1840, we selected the common law of England, 1776, which said even back then that if anyone died and would leave me an inheritance, I could be the trustee of the trust in charge of it. I could be the beneficiary as long as I can't give myself more than what I need for health, education, and maintenance, which is anything I need, by the way. And I can direct how it goes when I die, and my creditors cannot ever touch it, ever. So why would I leave assets directly to my daughter? Well, my daughter is very trustworthy. Some of you know my daughter. She's obviously very tolerant because she's still my daughter. But if I leave assets to her as trustee of a trust, then can't get lost to a creditor, can't get lost in a divorce, which I can't imagine would ever happen, but it can't. And on her death, it will never be subject to federal estate tax. So I just tell you over and over again, they bring me a wonderfully written will and it all says, yeah, and the children get it when they're 35. Well, no, they lose it when they're 35. So if you want to be safer, and what Marcia and I have in our documents is if Marcia passes away, our office building and some other assets are in a trust. I am co-trustee co-trustee, not sole trustee, with my choice of our CPA friend, our pharmacist PhD friend, I have a lawyer friend, believe it or not, and or any trust company in the United States. So then I make my decision, I pick one or more of them, they're co-trustees with me, and they don't let me do anything stupid. They don't let me do anything stupid. So if I get a next spouse or an aggressive son-in-law or something like that, I'm protected. And if I don't like the arrangement, I just go ahead and replace them. I say, hey, Dan, you've been a great co-trustee. Don't like the color of your shirt today. Now Rose is going to be my co-trustee. So all those people I named, close friends of ours, will not let us do anything stupid. They might let me do things a little bit silly, but I don't want to be able to do anything stupid. So just be thinking about, please think about this. And if you don't have the answer, guess one, because it's better than nothing. Who could be the co-trustee with your spouse? And by the way, a lot of Maui people choose their advisors to be a potential co-trustee. And I have done the same thing in my estate plan. So, it's people you trust. It's people you trust. Okay, so protected for the lifetime of the children. Another thing I want to mention is that I've done several estate plans in the last couple of years where each child is going to get $250 million or more, and they are going to be co-trustee with one of the largest trust companies in the country, and they're going to be able to switch to another of the top 5 trust companies in the country, and with their $250 million or higher inheritance, they're going to be able to withdraw when they have been self-sufficient for 5 years with a graduate degree. They will be able to withdraw $20,000 a month, adjusted for inflation, for the rest of their life. Because my clients in that net worth say, the last thing I want to do is ruin my child. Robert Heinlein, one of my favorite authors, said, don't ruin your children's lives by making it easy. And we see this over and over and over again, where people inherit $20 million, and I cannot get them to show up at the office to sign a document so I can give them their $20 million, because they're too busy watching TV, getting high, and eating potato chips. So, or whatever it is they're doing. So these, cutting them back to what you think a reasonable standard of living is. Now, beyond that, if they work for the business, then they can go to McKesson and Company or one of the big 4 CPA firms and get a letter of opinion written conservatively as to what they're worth as a CEO. Other than that, we want the wealth reinvested or going to charity. So just think about that. That may not be what you like, but I can tell you that that's what a lot of my very wealthy clients like, and they didn't get wealthy by being dumb. They got wealthy by being pretty smart. And they do love their children, and the last thing they want to do is take the life journey away from the child. You don't want to ever deprive someone of their life journey, because I can tell you about some incredibly miserable people with incredibly large amounts of money that's getting wasted because they're miserable in more ways than one. That's encouraging, right? Okay. So now so there's a process. The process is you hire me. No, the process is get your information together. You may have a personal financial statement, or you type out a summary. Get copies of your statements. This is on page, I don't have all the pages here. So this is just on screen. But you can get a copy of this PowerPoint. But anyway, figure out what you own. And by the way, do you have buy-sell agreements? Please have buy-sell agreements so that if something happens and your partner turns out to have a stroke and only have an 80 IQ and to be nasty, that you can somehow find a way out of that thing, or when somebody dies, please have a buy-sell. And then who do you work with? Well, don't work just with a lawyer. Get your coach involved. They know you, they know your family, they know your business. Get your CPA involved. They can be very good advisors. get as many lawyers as you need involved, and get the job done. You know, sometimes I feel like a health spa because people pay us a lot of money to produce beautiful documents. We send them out. We make 5 phone calls. We never hear back. And I say, wow, this is great. The profit margin on this one's really high. And then they come back when they're about to go into surgery and they say, oh, I have surgery on Wednesday. Oh, well, I'm glad you called me Monday afternoon to let me know you have surgery on Wednesday. So, you know, please make it a priority. And like David says, just get it out of the way. Now, I have some slides here on creditor protection, and what I heard from a lot of you today is you've got umbrella coverage. You've got umbrella coverage, and you don't really need to worry about creditor protection. Well, I mean, I had a client that just settled something very similar to that. A 26-year-old promising student was stopped in the smog, or not smog, in the fog, and a truck rear-ended her, and she will never have a feeling below her waist again. And that's about $40 million. That is not $1 million, and I don't care if you have a $5 million umbrella or a $10 million umbrella, and David Blaine knows this too, because we see it. This stuff happens, and the juries, so this is a 13-year-old, and he died. So, I mean, the parents had no lost income from losing a 13-year-old. Some people even want to lose a 13-year-old, but this jury awarded $32 million, and here's one, a peanut butter pretzel. Somebody gave this person a peanut butter pretzel, and it was a very expensive peanut butter pretzel. It cost $29.5 million. And here's one person died in one accident, $730 million. And these are all within the last 2 years. Hey, how do you like this one? You guys, how many of you do rental stuff and you have buildings? These fluorescent bulbs poisoned the Washington State teachers $185 million because the light bulbs poisoned the teachers. And I'm not trying to say that they didn't get poisoned. They probably did get poisoned. My question is, who paid the $185 million? Here's $38.8 million because a garbage truck hit a girl. And then this is one of my favorites because, well, I'm sadistic. That's one reason. But so lady takes her 9-year-old daughter to Target. Daughter sees a hypodermic needle on the ground and picks it up and starts playing with it. The mother goes, bats it out of her hand. The mother gets stuck. The mother goes to the emergency room. They give her the mother shots, tetanus and stuff. The mother gets real sick. She sues. She offers to settle this case for $12,000 the morning of the jury trial. Target says, no, we're taking this all the way to jury. This is ridiculous. $4.6 million against Target, which is why stuff costs so much at Target now. And $48 million because a bus stop fell on her in the rain. IKEA, $46 million because a shelf fell on a child. And IKEA should have known that the shelves were top heavy and would fall on a child. So anyway, and then this is very common. Pizza Hut, this pizza cost, I think, $8.6 million. So, you know, one thing I want to mention is if you have a business where there's vehicles, get rid of them. Get your people bicycles or have them ride the subway or get them on Ubers or set up a separate transportation company. So a couple of things we've done recently is we had a retail plumber and a commercial plumber, and all the vehicles were in these plumbing entities. We moved the plumbing entities into a third entity called Trucks and Plumbers, LLC, put all the plumbers in there, put all the trucks in there, and then they hire as independent contractors to the commercial plumbing company and to the retail plumbing company. So now if a truck if one of those people driving on their way to a job kills somebody, this particular client has 87 vehicles on the road, then most likely the lawsuit will be limited to the company that owns the trucks and contracts the vehicles. And there's actual case we have from Jacksonville where a DHL driver ran someone over, and it turned out he was not working for DHL. He was working for a Jacksonville company that contracts for DHL. He was wearing a DHL uniform, driving a DHL labeled truck, following every DHL office manual. and the people he hit did not have a shot at DHL. So that's why it's just important. And, if you can get someone else to drive, it's great. And if you can just tell your employees to leave that vehicle at your place of business and don't take it home, because you know what happens on the way home. They stop at a bar, and then you know what happens after they stop at a bar. So just, be careful. And then, of course, I've used this thing for years, and it is Sunday, so we can get a little religious and say, it was not raining when Noah built the ark. You can call me right after this stuff happens, but the solution is not as good if you get it squared away earlier. Okay, so now, page 15. I'm going to go through some definitions. You could take notes if you like. Okay, a revocable trust. So a trust is a contract. It's a contract between a trustee and a settlor or a grantor for the benefit of a beneficiary. So technically, when I teach at the law school, I have to explain, a trust is not like a company, it's not an entity, it's an agreement between me and me and me. So Alan Gassman, as trustee of the Alan Gassman Revocable Trust, hereby signs this trust agreement, which says that I'm the trustee, the trust is for me, I'm setting it up, and I can change it anytime I want. And that's called a revocable trust. And why on earth would I set up a revocable trust? And the answer to that is a cheerful little word called probate. So if I die with a bank account in my name, Marcia walks into the bank and says, hey, bad news, Alan died. Good news, a lot in this account. Can you please give it to me? Here's his death certificate. Here's his will. Well, the bank says, wait a minute, we live in Florida. We don't want you to be able to get that money unless you pay the creditors, unless you pay the IRS, unless you pay the lawyer who goes to court with you in order to make sure all that gets done, unless you pay the court costs so you could support the judge as well, and the list goes on and on. So that's a bureaucratic thing. Probate is a bureaucratic thing. It's not a tax, and it's not terrible. It may cost, on average, $3,000 to $6,000. So it's just, I'm not going to tell you that probate's a big thing and you should jump up and down and avoid probate at all costs. The main thing is appoint a personal representative or executor under your will who will not rip you off. If you appoint certain people, they will rip you off. If you appoint your sister or your brother or your longtime CPA, they probably won't rip you off. But that's probate. But if I put that bank account in the name Alan Gassman as trustee of the Alan Gassman Revocable Trust, and I die, she walks into the bank with the trust, the death certificate, big smile on her face, and they give her the money. So there's no delay from probate. Now, when I started practicing law in 1984, before I invented the internet, we normally did really long, complicated wills for people, and then if they asked for a trust, we would do a long, complicated trust. But now what we do is we do what's called a pour-over will, okay? And it has nothing to do with Passover, it's pour-over. And what it says is, if I die and there's anything in my name, my will simply says, put it all in the trust. So almost every estate plan in the United States now, drafted by competent legal counsel, or even LegalZoom, which I don't care for, by the way, has a pour-over will and into a more complicated revocable trust. But then what I have to tell you is really important is don't put anything in your trust unless you understand that creditors can reach what is in my revocable trust. So my revocable trust avoids probate. It can avoid guardianship if I lose my marbles, or even worse than I already have, but it will not avoid creditors. So I have a lot of people who come to me and say, oh my gosh, I was in a car accident, but I'm really glad that my lawyer set up a revocable trust because all my assets are in there. And I say, okay, cause of action against the lawyer. All right. So then, powers of attorney. A power of attorney is very, very important. I hereby give Marcia the right to sign my name for anything on earth. She can sign my name for anything on earth, And then you need all the right language for this. If you go to any bookstore in Florida and buy any durable power of attorney from any bookstore in Florida, it is defective and will not work because Florida has a complicated durable power of attorney statute. So just make sure that a lawyer who understands your state has approved your power of attorney, and then decide who you're going to give it to. And you could give it to your spouse, you could give it to your friend, you can give it to your CPA. I like to give it to 3 or 4 people at the same time, because whoever is trustworthy and can come help me, please come help me. Because usually when you need to use a durable power of attorney, things are not going well. So that's the durable power of attorney. And I want to mention there's a healthcare power of attorney. And the healthcare power of attorney usually is less tricky. It's a shorter document. And one of the things that our healthcare power of attorney says, unless the client wants otherwise, is that the agent has the power to transfer my client by airplane to a state that allows mercy killing, if you want that. Or if you don't want that, make sure you state it. But the biggest mistake I think that a lot of us make with the healthcare power of attorney, say, well, I appoint Marcia. If Marcia can't do it, I appoint my daughter, Nicole. If she can't do it, I appoint my friend Hitesh Patel. Well, mine says I appoint Marcia, Nicole, my friend Hitesh Patel, my friend Dr. KB Lee, and 2 other people, all to be my agent, to have the authority now, because whoever gets to intensive care first, I want to be able to speak for me, and whoever happens to be there at 3 in the morning and the nurse won't let them look at the chart, and by the way, please give my mother a Tylenol, and I want a second opinion, put in everybody, put in the troops for that document. Not just, and to give that authority to a 20-year-old, do you know what you're putting your 20-year-old through to have to go through that, and how intimidated a 20-year-old can be in the hospital bureaucracy? So, no offense to the hospital bureaucracy. Some of my best friends are hospitals, but let's just, try to be careful there. So for a lot of you, number 3 is to do the same thing for your parents. And in particular, if you have parents that are going to leave you significant wealth, I don't want to inherit directly. They can leave it to a trust where I'm the trustee. I get what I need for health, education, and maintenance. I can direct where it goes when I die. My creditors can't take it. I can't lose it in a divorce, et cetera, et cetera. And before I forget, there is an income tax strategy that has become very popular, and that is to give an old person with a short life expectancy a power to direct assets in an irrevocable trust. And the way this works is I set up an irrevocable trust for Marcia and our descendants. Marcia is the trustee of this trust, and I put our stock portfolio in it, and I put our business building in it. And then I also say that Marcia's father, who is 92 years old and doing well, and her mother, who is 87 years old and doing well, are potential beneficiaries of this trust. And they also have, and this is really technical, they each have the power on death to direct the trust assets to creditors of their estate, but only with the permission of our next door neighbor. Okay? Well, to you as a layman, I just gave my father-in-law no power at all, because my next door neighbor is not going to allow him to exercise that power of appointment. But under an Internal Revenue Code provision, 1014A, or 1014E, I'm sorry, when my father-in-law dies, I get a new fair market value date of death basis. So my office building, which is now almost completely depreciated, would get a new income tax basis on his death to allow me to take depreciation all over again. Or a stock portfolio that has a cost basis of $2 million, it's now worth $10 million. He dies, now the cost basis is $10 million, and I can sell the portfolio and pay no capital gains tax. So you may find a way to like your mother-in-law after all. And we're doing this right now for a gentleman who has, a lot of assets. So we're taking about $90 million of fully depreciated commercial real estate, putting it into an LLC subject to an $80 million mortgage, putting that in an irrevocable trust, and giving his aunt the power of appointment. So it'll be sad when she dies, but not as sad as it would have been. All right. Well, you know, I deal with this stuff. All right, asset protection. By the way, has anybody seen my YouTube videos on Saturday at 11 a.m.? Okay, a couple of you have. So every Saturday at 11 a.m., usually I give a webinar. Starts off with a stupid puppet, and then a stupid speaker, me, and we talk about all this stuff. And you can go to my YouTube channel and find a lot of these subjects covered. Before I go to asset protection, or after asset protection, I want to mention confidentiality, because a lot of people do want confidentiality, particular medical professionals, high-profile people, judges want confidentiality. You don't want a customer who's upset to have the ability to, in 5 minutes, find out where you live and go there. So, or to go to the Secretary of State website of the state where your company is, and in 5 minutes know who you are and what your address is. So for a lot of you, and thank you very much for allowing us to do this, we set up usually a Wyoming, or sometimes Colorado, or sometimes Delaware LLC. Those states do not tell anyone who owns or manages those entities. And then we make that Wyoming LLC the manager of your Florida or California LLC. So now they go to the website and all they see is a Wyoming LLC. Then they go to the Wyoming website. Wyoming doesn't tell them anywhere. And then hopefully they cool down and don't come over and shoot you. So that's the logic there. And then we do the same thing with your homestead, that we could take your homestead and put it in a revocable trust and make the trustee of that trust that Colorado or Wyoming LLC, and then people just don't see your name all over the place. And if you want to know about somebody in Florida, all you have to do is hit Google Sunbiz, S-U-N-B-I-Z, and up comes the name of that person. Google Sunbiz, Alan Gassman, up comes, you don't even have to go to the Sunbiz website, that just pulls it all right up. And you know, we're all only $100 away from having a lot of our information go on a detective report, and these detective reports do not find these things when you use that sort of confidentiality. Most people don't go for that, but some people do. All right, asset protection for your business and investments. There are a lot of ways to protect assets within your business, and I'll give you some of them. Dividing things up into separate businesses. Like I had a talk with somebody today and they said, well, most of our inspection work, everybody signs the agreement which says they can't sue us, or, you know, but a couple of customers want us to sign their agreement, and these are bigger, you know, buildings and stuff. Well, set up a separate company for the big building inspections and let the second company sign those agreements. Keep the golden egg company that's laying the goose eggs, laying the golden goose eggs, unless you have a cholesterol problem, but keep that separate. So yeah, you got to set up a separate S corp. You got to have Kevin file one more tax return. You got to have another bank account, and then your business is not wiped out if an inspection report doesn't work right. So you have to decide if that's worth while or not. Okay, coordinate with income tax planning. You know, a lot of times I will confer with the CPA and the other tax advisors before we make any moves. Just make sure that what we're doing does not interfere with what needs to be done. And then the Spousal Limited Access Trust. That's like the new stylish player on the block, and it got a name. That's why it became stylish, the Spousal Limited Access Trust. And this is a trust that a lot of you do have. A lot of you here do have it. And I would set up an irrevocable trust for Marcia, just like I told you. I put the building in it, I put the stock in it, she's the trustee, she gets what she needs for health, education, maintenance, and support, herself and the children. My creditors can't touch it because it's not mine anymore. Her creditors can't touch it because I'm the one who funded it with my share of the marital assets. And then I could have a floating spouse provision in it. That's optional. And the floating spouse provision says if something happens, Marcia passes away, Alan's next spouse can receive benefits as needed for health, education, maintenance, and support, so I can indirectly get assets out of the trust, or I can locate the trust in an asset protection jurisdiction like Nevada, which I like best, and then if something unexpected happens, I can be added back into the trust as a beneficiary. And then everything in that trust is never subject to estate tax, so the growth estates the estate tax system, and that is called the SLAT. Now, what do you think they call the spousal limited unitrust? All right. All right. Then, you guys are easy. Okay, we talked about stepped up basis planning. Then LLC formalities and procedures. Yeah, when you get sued and you say, well, you can't sue me, it's all in an LLC. Of course, I haven't done annual minutes ever, and I forgot to do the tax return, and the checking account really is in my name and not the name of the LLC, but you really can't sue me. So just, we do annual minutes. We try to make sure that you're following the formalities and that you have a proper operating agreement. And I'm going to say that again because there's so much deficiency in operating agreements. So when you set up an LLC, you file articles of organization to get it filed, and you could do that on your own, but you probably shouldn't because you'll do it wrong. And then you can do an operating agreement because every LLC is supposed to have an operating agreement, and then you could do that wrong, and then that will screw up the tax treatment of the LLC and the creditor protection treatment of the LLC. And we review LLC operating agreements every week, and I think 30% of them have big defects. All right. Number 12, sign everything. Please sign everything. I had a client once he was a pretty good client, and I really liked him, and he gave me 4 days notice that he was going skydiving. And he would do skydiving in formation. So I sent him a will, and I sent him a trust, and he emailed me and said, all signed and in the safe deposit box. And then his parachute did not open, and a lot of the assets were in his personal name, and he did not sign the pour-over will. He only signed the trust. So everything in his estate went the wrong way because he had a new spouse and a new child, and everything did not go the right way because there wasn't time. He didn't sign it. So now my trust, my revocable trust says, this trust is also a pour-over will, and if I forget to sign a pour-over will, this trust is now a pour-over will in memory of this poor parachuter. And it's sad. It's a true story. So you just have to be careful, and you have to, bear with us. And then another thing I just wanted to mention is you should have a decent lawyer look at all your customer agreements, all your supplier agreements, all your leases. For example, under state law in most states, if you have a triple net lease and the language of the lease says that the tenant is responsible for all maintenance, all responsibilities concerning maintenance, then somebody trips and falls in your store and they cannot sue the landowner company. So you want to make sure you have that in your arm's length leases. Now, and I'll give you some examples, I think, when we get there. And then you can tell David there's a picture of him taking a shower at the end because you heard him say, get this done and take a shower. All right. So I'm going to mention the revocable trust again. I know some of you are slow learners. It can avoid probate, which is an administrative process. It can avoid guardianship. It gives no creditor protection or tax advantages during life. And your estate plan is normally baked into this document. So it's a very important document. On the other hand, you have an irrevocable trust. An irrevocable trust, not an irritable trust, just an irrevocable trust. And it says, I, Alan Gassman, form this trust, and it's irrevocable, and I can't get it back unless my friends, the trust protectors, maybe give it back to me, and it's for Marcia's lifetime benefit. So that's an irrevocable trust. And a lot of you should have an irrevocable trust for the reason that I mentioned. And And here is just a typical estate plan, but a very important estate plan. So on the top left, right, you have an irrevocable trust for your children, whether you like your children or not. It's an irrevocable trust. Your friend is the trustee. You have the right to replace your friend at any time. And then you have your revocable trust at the top. And then your business or your investment LLC goes down below that. And if you just do that part, the revocable trust owns 3%, and the revocable trust owns 97% now, and the irrevocable trust owns 3%, and somebody sues you while they can get into the revocable trust, in most states, they cannot reach into the LLC. So I own 97% of the LLC, you get a judgment against me for $100 million, you cannot reach into that LLC because of something called the charging order rules in most states. And then you see 0.5% V, that's for voting, and 2.5% NV, that's for non-voting. And then above 0.5% voting, and the revocable trust will have 96% non-voting, so that even if you could break in, you're not going to get enough voting stock to take that over. And those of you from West Virginia, that is not North Virginia, 2.5% North Virginia, it's 2.5% non-voting. Now, so that's good. And is that easy or not? Now, you say, why can't I just give 3% of the LLC to my mother-in-law or my best friend or directly to my children? One reason is that LLC may be disregarded for income tax purposes, so you're not having to file a tax return for it. A lot of you have LLCs that don't have to file tax returns. Well, if it's owned by somebody other than you, in 3%, then you got to file a partnership tax return, which costs a few $100s, if not thousands. Whereas if it's owned by an irrevocable trust for my children that's drafted in a certain way, that trust also does not need to file a tax return, so the LLC doesn't have to file a tax return, so I get rich, but not Kevin. But the LLC, the irrevocable trust, you form it, you sign it, you fund it, and then whenever you take a distribution out of the LLC, 3% goes to the trust for children, and that is used to pay expenses for the children that you would have spent. Now, if you want better creditor protection, not perfect, but better creditor protection, then you could think about forming an asset protection trust. So until 1992, every state in the United States followed the English common law, which said, if Alan set up a trust for Alan, the creditors can reach into the trust. That makes sense, right? Well, Alaska in 1992 passed a law that said, if Alan sets up a trust in Alaska and no one's chasing him that year, we're not going to let creditors in. And then Nevada followed suit, Delaware followed suit. Now there's 20 asset protection jurisdiction states. You may live in one of them. So now my daughter's best friend, who lives in Nevada, as trustee of the Nevada Trust for my family that I can be added to, owns 96%. And she consents to my taking out a few $100,000 a year without her permission. And we do annual minutes with her once a year, and every 3 years we go to Las Vegas and talk to her. We have a very important business meeting at a casino. And now if somebody gets a judgment against me, they have to do two things. They have to first go to Nevada to try to overthrow the Nevada Trust, and then if they can, which they might be able to, I'm not going to get into the generalities, but they might be able to, but then all they're going to get is a charging order. And until that happens, I'm going to have all the access to the cash flow. So that has become a much less expensive and fairly, as a practical matter, my experience with banks and financial institutions who go, oh yeah, I'm just going to break through that Nevada Trust after I pay my lawyer $150,000 in litigation fees. They just say, hey, can we please settle this? So it's just you're better positioned to settle. Now, the other thing that happens is, let's say that business or investment LLC is worth $20 million and you die. Okay, what is in your estate tax return? Well, 3% is out, so we save 3%, but let me ask you, what would you pay me for 97% ownership of an LLC that I control and you don't control? Would you pay me 20 mil? 15 mil? So the tax court has usually said it's worth about 14 mil. About a 35% discount is where the tax court's been coming down, sometimes less. So this will save a lot of estate tax. Grandma comes to me with a $15 million estate. She wants to stay under $12,920,000. This is all I have to do. All I have to do is the revocable trust and the irrevocable trust, put her investments in the LLC. While you're at it, though, the revocable trust for grandma should have a safety latch provision which says I can't change this unless 2 neurologists, 2 psychiatrists, or 2 out of my 3 children say I have my marbles, so that the fortune is not inherited by a nurse. Which, if you want to be a multimillionaire in Tampa Bay area, just specialize in being a housekeeper for elderly people. And I had a client who almost died from misuse by a housekeeper who endeared herself to the family and managed to estrange the lady from her children. And when I called a lawyer who had history with her, he said, she became the nurse for 3 of my clients, and they are all dead now. And she inherited from all 3. So I stopped number 4, and the police wanted nothing to do with it. They would not even investigated it after I had her on videotape in my office lying about what was going on. So, word to the wise, if you love your parents or you love their assets, stay involved. All right. I'm gonna write that one down. All right. So here's a typical revocable trust. Somebody wanted to know what's an AB trust, and this is what they used to call it, but that's my revocable trust. Let's say I've got 15 million in it. On my death, it becomes a family trust for Marcia, filled with $12,920,000 of joy, and anything above that goes to a marital deduction trust. This is, if you're wealthy, this is probably what you want, and if you're not wealthy, it's still what you want. Because when I die, I don't want it to go to Marcia. Like I said, I love Marcia very much. I want to protect Marcia, and therefore, health, education, maintenance, and support. I just want to mention community property, because I know a lot of you are from California, and you have my condolences. But California and Texas and about 7 other states, including Wisconsin, have community property laws which came from Spain and France. And under Spanish law and French law and Louisiana law, which is crazy too, anything I acquire during the marriage while we reside in that state belongs to both of us and it's community property. So I own half, Marcia owns half. And then let's say I put it in Marcia's name because I don't want to get sued, and then I get sued, they get a big judgment against me, and because it is community property, they can take all of Marcia's assets. Community property, Texas and California, bad stuff. Bad stuff. Now, the good part of community property is if one of us dies, you get a full step up in basis, which is nice. I can do that other ways. But for most of you who are our clients, we have transmuted you out of community property treatment and then put the assets in a secure slat or in the name of the spouse who's not going to be the one getting in trouble with liability. So that's called transmuting out of community property. And if you have a lawyer who hasn't transmuted you out, you got to call. Why didn't you transmute me out? Well, I just didn't think about it. I just didn't think about it. It's not the way we normally do it here. So that doesn't mean it's the right way to do it. And then you've got the spousal asset preservation system, which I'm sure some of you remember. I don't have any new jokes, but I have an old one. The guy goes golfing with his wife. She has a terminal disease, and she says, I got to ask you something. I love playing golf with you. When I die, what are you going to do with my clubs? And he says, well, I just love playing golf with you, and I'm going to remarry, and I'm going to give your clubs to my next wife, and it's going to be just a great experience. And she says, oh, that doesn't feel right, but the other thing is, I'm a lefty. And he goes, well, so is she. So... All right. So I have 10 minutes known as 3/10 of a billable hour. I want to invite Rob and Claudia Rousel up. They win the Chart of the Year award. As far as I know, we're the only law firm that does this, but we always display for me and the client every entity. So here you have them at the top, and you have her picture, but not his, because she looks good and he doesn't. And there you would have the joint assets, and there you might have an irrevocable trust, an old one from back when, and there you might have a new slat. You might have an irrevocable gifting trust, and then you would have a circle for every single entity and where they exist and what their relationships are with each other. So you would have lines to show promissory notes and things like that. And then below each circle, I have each piece of property and what its mortgage amount is. So now I can look at this and say, well, I'll do this, I'll do that. You know, I mean, Einstein wasn't necessarily a genius. He looked at things. He found a way to look at things. So thank you, those of you who are clients, the vast majority of you have these. I'm sure many of you have chart envy right now. I can understand that. We have one chart that would more than cover this whole stage. So keep on adding LLCs, everybody. So there you go.
Oh my God.
This is an alligator. Watch out for them in all walks of life. All right. Let's see what else we had. I'll just show you a couple more things, show and tell, and then we'll open up for questions. So this is an electrical contractor. They do big jobs and little jobs, and then they have a bunch of vehicles and drivers, so we put them all in 3 different companies with agreements between them, had it approved by the insurance company. It fits the case law of their state, so they don't have to lose everything over a car accident. Here, a similar situation, and then let me see here, what else I will cover. A lot of problems with LLCs, but you can read about that on your own. Community property states there, if you're in Arizona, California, Idaho, Louisiana, Nevada, North Mexico, Texas, Washington, or Wisconsin, don't go back. An article on the inheritance trust. If you get an inheritance trust, if your parents don't want to do the inheritance trust or their lawyer doesn't want to do it, it takes forever, you do the inheritance trust and then they just change the beneficiary of their will to the inheritance trust. There's a beautiful picture of a slat. Didn't keep the slut picture in. Okay. Then here you have a client on the left. This is the biggest estate tax planning technique. So this is the estate tax planning technique. If it doesn't fit you now, I hope you go to Hawaii and come back, and it will within a year or two. So what I do here in this example, and this is a really old one, it's from 2011, is the client put $3 million worth of assets into an LLC or a limited partnership. $3 million worth of assets. Of course, maybe they were worth $4 million, but we were able to get an appraiser to say $3 million. Matter of opinion. So then on day one, the client owned 100% of that limited partnership or LLC, and we set up a beautiful irrevocable trust for the children or the spouse and the children, and that we call that, nowadays we call it a dynasty trust. And if you do it in Florida or South Dakota, it can go 1,000 years. Texas, only 300 years. And what we do is now I give a $300,000 gift to the irrevocable trust as a gift. I call it a seed capital gift. And then what do you think 99% of a $3 million LLC is worth if it's non-voting? It's worth maybe 2/3. So I take back a $2 million note So what have I done? I've taken $3 million worth of assets on day one, and I've converted it to a $2 million note. And the note, if you do it a year ago, it would have borne interest at 2%. You could go 20 years, 2% interest only. Now it's going to be about 3.8% because the interest rates are going up. So the trust, now this will blow your minds, you'll be so excited tonight. The trust is disregarded for income tax purposes, so there's no income tax on any of this. It just all goes on my Form 1040. So what have I done? I have this beautiful business or investment that's shooting off income and growth, and my estate stays at $2 million plus interest, while what's passing to the gift trust, because of its 99% ownership, is never in my estate. So we fast forward 10 years, and now after all the interest payments, which I ran this at 6% and a 10% rate of return, at the end of 10 years, the gifting trust is worth $4,489,000, and my net worth is $3,006,000. So based on a $300,000 gift, I have gotten $4,480,000 out of the client's estate for estate tax purposes. So if you multiply all your numbers by 10, then we've kept about 41 million out. So it's called an installment sale to a defective grantor trust. It's got a really fancy name, and it's all on my YouTube channel. If you can't sleep, it's a great place to go. So who has the first question? You've got me for, how long do we have? Going an hour? I think we have another 15 minutes. Does anyone have a question? Or should I just keep going on and on and on? Thank you, Jeff Trena. The question was, how does it work if you live in one state and your assets are in another state and you have your entities in another state? The answer is it works very well for me because then I have a lot of work to do. But no matter where your assets are, whether they are offshore or onshore, all of these techniques work just fine. It just takes a little bit of coordination. Who has the next question? Yes.
I had a question about offshore asset protection. There's an issue with movements of money, like especially a lot of folks here could be sending wires and moving, 6 figures or more for all sorts of real estate transactions. And when you have, at least from what I've heard, and moving things in and out of foreign, especially foreign money, that raises red flags that can be held because of TSA and other measures that are sort of.
Yeah, that's a really good question. The question is, if you do an offshore asset protection trust or you have offshore transactions, are you attracting a lot of IRS or other governmental scrutiny? And the short answer is no, because there are so many international transactions coming in and out of the United States, there is no way that the government could even try to keep track of them. So we have a couple of clients based in Europe who are quite wealthy, and they regularly wire to and from us and others tens of millions of dollars, and the bank calls and says, what's it for? We explain it, who it is and what it's for. We file all the IRS forms, and I don't have any problem with that at all. Plus that we do everything right, of course, for this client. If the IRS shows up, I don't have any problem with it. But I will say that if you set up an offshore irrevocable trust, which we do a few of those because it's really hard for anyone to touch them, you have to file a Form 3520 with the Internal Revenue Service by April 15th of the year you set the trust up, or the penalty is 35% of what went in the trust. So if there was just a court case that came down, and these people filed 3 years late, they blamed it on their accountant, and there were about $30 million in the trust, so their penalty was over $10 million. They could not get out of that penalty. So if you're going to go offshore, and we maintain a few offshore structures, and in fact, I went to an event last night in St. Pete, and I met with a banker who is in Liechtenstein, and that's where a lot of U.S. money is going nowadays. If you want to try to keep it safe, it's considered to be a very safe jurisdiction because they don't have reciprocal enforcement treaty with the United States. So you say to the bank, well, I'm sorry, I can't pay you, and I'm sorry that 5 years ago I put a couple of million over in Zurich under an irrevocable Isle of Man trust, and I'm sorry you can't touch that, but you can't touch that. And the bank says, yeah, I guess you're right. I guess we can't touch that. It wasn't on your financial statement. We didn't rely on it, but that is the typical structure is up here. You've got the irrevocable offshore trust agreement. You've got a trustee offshore, which should be a respected trust company that's been there a long time and is going to be there a long time. And then we drop a LLC. Typically, we could use an Isle of Man trust company, and then we put the LLC in Nevis. So they have to sue in both jurisdictions to get hold of it. And then the Nevis LLC can own a Liechtenstein or Swiss account. And good luck to a creditor who wants to unwind that, but you have to file the right tax returns. There's no tax cost, but you do have to file the right returns. Next question. Yes?
Any recommendations on employees that are using their own personal vehicles?
Oh, your own personal vehicles? Is that the question? Okay. Where would you, if you have to own a car, I guess you do, just own the car in your name. Just, I own my car, Marcia owns her car. Our daughter Nicole owns her car. Our son-in-law Dave owns his car. Now, under Florida law, there's a statute that says that if I let you use my car and you're in an accident and you have at least $500,000 of insurance, I'm not responsible unless I was negligent in allowing you to use the car. So, of course, the plaintiff lawyers say, well, you were very negligent in allowing Marcia to use your car. You know she can't see well at night, don't you? Or you know she texts and drives, don't you? You should have known. So I just think that it's astounding how many people have children driving their cars. Try not to do that. In most states also, in Florida, if I take my child to the driver license bureau and sign for the permit, I'm responsible for all negligence on the roadway until the child reaches age 18. So the last thing I want to do, have your housekeeper or your mother-in-law take them down to get that thing signed. Clients come to me and the wife took the child down. I didn't mean to call it an it. I haven't even seen it. But the child goes down. The mother takes them to get the thing, signs, and then the child's driving the father's car. That's really, really very dangerous. Who else? Yes?
So the question I was actually asking was that employees of your company that are using their own personal vehicles get to where they find locations, any suggestions on that?
Yeah, when employees use their own vehicles, you want to make sure that you have unowned, UNOWNED, liability coverage, and that you have a very strict code of conduct of what they are doing and when they are driving their vehicle for you. When they're driving to and from work, you're not responsible. But when they're driving, if it's a doctor and he's driving from hospital to hospital, you are responsible. So you want to have a lot of coverage. Or possibly put all those employees' cars into an independent contractor company like I mentioned, so you don't have the liability. Everybody here knows you should know the Latin term respondeat superior, which is anything my employee does is my fault. So I say to my receptionist, go across the street and get a box of cookies and bring them back and put them on the conference room, because Kevin Bassett's going to come over and he always eats all our cookies, so we need extra. And then she's in a car accident on the way across the street, and I can lose everything. So I'd rather not lose everything, right? So what can I do? Well, I can, and for a lot of you, we have done this. You have one company, and it's the golden egg is in there, and the intellectual property is in there, and your goodwill is in there, and it's all in this one company. Your accounts receivable, isn't that scary? It's all in this one company. And if you pull appreciated assets out of an S corporation or a C corporation, you trigger income tax as if you sold them. So it's not like I could just pull your letters of protection worth tens of millions of dollars out of your company, because then you'd have to pay income tax as if you got paid. So what I can do is I can put up a new parent company. So here's my old company, here's my new parent company, and it can be an S Corp or a C Corp. I set up NewCo, that's what we call them now, NewCo, the new parent company, and I transfer my ownership of OldCo, also known as Goose Laying Golden Eggs, to become a subsidiary of my new parent company. And under the Treasury regulations, the new parent company assumes the tax identity of the subsidiary company, so there's no tax, there's no extra tax return. The next tax return just shows the new name with the new tax ID number. The subsidiary company keeps its name, keeps its taxpayer identification number, and now it can move the assets to what we used to call brother-sister companies. I think I have to call them sibling companies now. But now I have a parent company and 4 siblings owned by the parent. The parent owns the Golden Goose Company, the parent owns the intellectual property company, the parent owns the accounts receivable company, and the parent owns the furniture and equipment company, and the parent owns the vehicle company. And these are all owned by the same parent company, and now you sue any one of those companies, and you cannot get through that company up to the parent or over to the sibling companies. And it's called a new parent, F as in Frank, reorganization under Code Section 368A1, capital A, which I still remember from law school, thank heaven. And it's pretty easy to do. So think about it. I know a lot, even from conversations that I've had today, I know a lot of you have all the eggs in that one basket, and then your receptionist is going to go get cookies for Kevin Bassett. Do not get cookies for Kevin Bassett, ever. Yes?
So my businesses are in Ohio. You represent someone that's not in Florida?
Yeah. I'm not here to advertise, but the law in the 50 states, the law in the 50 states is pretty common. And then there's lawyers in all states that will help lawyers from other states. So if your lawyer wants my assistance, or I want lawyer assistance from somebody in Ohio, the DNA is 90% the same, if sometimes 95, but it depends on the state, if that helps. By the way, I do have a table out there and with an appointment book out there. So, because otherwise I don't do a good job at taking business cards, and I'm supposed to call you and all that stuff. So I do have a table out there. Yes?
If you own like a $250 million company, is there anything you should be like paying attention to about?
A water filter company?
No, a $250 million company. Like you're just doing 150 grand a year. You're not doing, even $1 million. Is there anything I should be paying attention to at this time?
Yeah, grow it. Take 20% growth and call me in the morning.
The vehicles and the drivers need to be in a separate company.
We put the drivers and the vehicles together because the driver and the vehicle are going down together. So there's just it doesn't usually do a lot of good to put the vehicles separate from the drivers unless you are afraid that the driver is going to do something separate and apart from the vehicle. So, but normally we put them together, but we're glad to take them apart. Yep.
We had a guy driving 100 miles an hour in a little Versa note, all branded and everything, and so we slapped him around, counseled him and everything else, and he's not driving that far anymore.
Yeah.
We have vehicle trackers in, that good enough for something like that, gross negligence.
You know, it would just be better to let your son-in-law own the transportation company, give him 10 or 20% ownership, and let a true independent contractor relationship. You know, the best thing for the cars is just take those cars, put them in a separate company, and then have somebody, your dispatcher or your best friend from high school or someone you don't like, somebody, make them a part owner of it so it's truly at arm's length. Let them make some money on it. So when that car causes, a lot of people to die, it's much less likely that they're going to come through. And by the way, don't think that you have enough liability insurance, because most of us don't. And don't think that you can't get more for less money. A lot of you have been very loyal to an insurance agent, which may be a State Farm agent or an Allstate agent and they've been good for you and you've outgrown them. So get second opinions on your insurance. I mean, what I could just tell you, I strongly recommend every 2 years, just send all your insurance coverages to a very big agency somewhere. Say, here's what I got. Can you do better? And then if they can do better, then you could take that right back to your old agent and say, can you go ahead and do these things that you should have done? You know, these agents, they work on a 3 to 4% commission. They don't get paid nearly enough to spend the time and the attention that you deserve to have spent. So you just have to, you know, try to find somebody who's more sophisticated to do that commercial insurance. A lot of us here use Holly Kerr at Hub Insurance in Tampa. She's got an MBA and she acts like she has an MBA. So I would say that's something worth mentioning. Yes.
I was going to ask, how large is the margin of error in actually setting up these systems? Because with the level of complexity of the system changes, what sounds like tax law rules, state rules, is it necessary to have it done twice?
Okay, the question is, what's the margin of error and how many times do you have to redo it? Well, hopefully as many times as possible, but no, most of these, you know, look, if you're going to be a successful business person, and I think everyone in this room can be and will be or is a successful business person, you have to do your books right. You have to keep your bank accounts right. You should reconcile your bank accounts. You should have a competent CPA, and you should be able to do this. You should be able to have a parent company that owns a subsidiary, 3 subsidiaries along the row, and it costs you an extra $264.50 a month to protect yourself. So that's my answer. It's not, once you set it up, it doesn't have to be redone. Typically, every structure I've shown you here, I was doing 15 years ago. I'm still doing them. They haven't changed. We're always tweaking, but it's fundamentally, I think David's seen many of our structures. And if you get it done right the first time and just get it done right, then check with us every maybe 2 or 3 years. It's not that big of a deal compared to what a big a deal it is when I get that call at 8 o'clock in the morning or 6 a.m. saying, I've been emailing you all weekend, our truck got in an accident. You know, you just got to prioritize that and try to get it right. Who else? Yes.
We own a mechanic shop, fix cars. We're not going to wait. Is there a way to separate liability from what we do?
Yeah, well, do you want to put a separate shop in each company? So, because that's the horrific thing about mechanical is when an axle breaks, you're going down. So separate company for each location. You know, if I die at Burger King from poisoning, they're only losing one Burger King, the one I was sitting in. They're not going to lose all the Burger Kings. So now don't dissuade you from going to Burger King. I was only using them as an example. Krispy Kreme, though, will rot your veins. Yes?
Hey, I'm Stephanie, dermatologist. Is it better to have my medical practice in a separate LLC than my cosmetic, like having a
Yes, I have, Stephanie's a dermatologist, and she doesn't want to do anything rash. So and it's a great specialty because nobody gets better, they just keep coming back. So, yes, I have a lot of plastic surgeons and dermatologists where there's one parent company, and then below it is the cosmetology and that nurse practitioner who does the hair removal and all that stuff. And then on the other side, the second subsidiary is the dermatologist. So if something crazy goes on in your med spa, you don't lose everything. But you have to talk to a healthcare lawyer. Yeah, one thing I'm going to mention a lot of you are in the medical. We always confer with a healthcare lawyer. I used to write books on healthcare, and I used to practice healthcare law, and it is really complicated. So it's not a big deal, but you can't just have an estate planning lawyer and a tax lawyer anymore. You have to have a healthcare lawyer when you do this structuring, because it can be very state specific, and then the way your malpractice insurance works could influence it. So, okay, I've got time for one more question. What's that? We have another hour? Oh. Half an hour?
I just wanted to ask, how do you know if your umbrella policy has enough insurance? Like what kind of...
Well, first of all, it doesn't. So the question is, how do you know if your umbrella policy has enough insurance? Well, it automatically, for personal umbrella, it automatically goes to 5. So look at the pricing of 2, 3, 4, and 5. It may only be $300 a level, but it automatically should go to 5. Even if you just call Progressive 1-800, it's going to go to 5. The question is, what does it cost to go to the next thing 10? What does it cost to go to the next thing 20? And then the really tricky thing is, for a lot of you, is you think you have this coverage because you have an umbrella, but the umbrella only covers your home. It doesn't really cover the rental property because you didn't even tell them about the rental property. The rental property's in another state. The agent didn't realize that. They wrote it down that it was in your state. I just can't, when in our profession, when someone gets in an accident, first there's a mad rush to the policy. Because the first thing we think is, in Tampa here, there's probably 25 lawyers doing nothing every day but litigating over whether the carrier has to cover the problem. And then when the carrier won't cover it, can we sue the agency? So you have to be, I'll just say you have to be very careful. And, from my vantage point, as much as you can afford, but can you, if you're single and you have a Nevada Asset Protection Trust, is that 100% reliable? No. You might want to have 10 million umbrella. If you're married and the assets are all in your spouse's name, maybe a 3 million umbrella. You've got to just kind of balance it, and it's an art and not a science. So I want to give you your break. I want to thank you very much for paying attention. If you have any questions, give me a call. Thank you.